South Asian Association for Regional Cooperation, SAARC, Regional Convention on Suppression of Terrorism. Signed at Kathmandu on 4 November 1987, in force on 22 August 1988, Depository, Secretary-General of the South Asian Association for Regional Cooperation. The member states of the South Asian Association for Regional Cooperation, SAARC. Mindful of the principles of cooperation enshrined in the SAARC Charter. Recalling that at the Dhaka Summit on December 7–8, 1985, the heads of state or government of the member states of the SAARC recognized the seriousness of the problem of terrorism as it affects the security and stability of the region. Also recalling the Bangalore Summit Declaration of 17 November 1986, in which the heads of state or government of SAARC agreed that cooperation among SAARC states was vital if terrorism was to be prevented and eliminated from the region, and unequivocally condemned all acts, methods and practices of terrorism as criminal and deplored their impact on life and property, socio-economic development, political stability, regional and international peace and cooperation, and recognized the importance of the principles laid down in UN Resolution 2625, which among others required that each state should refrain from organizing, instigating, assisting or participating in acts of civil strife or terrorist acts in another state, or acquiescing in organized activities within its territory directed towards the commission of such acts. Aware of the danger posed by the spread of terrorism and its harmful effect on peace, cooperation, friendship and good neighborly relations, and which could also jeopardize the sovereignty and territorial integrity of states, have resolved to take effective measures to ensure that perpetrators of terroristic acts do not escape prosecution and punishment by providing for their extradition or prosecution, and to this end, have agreed as follows. Article 1. Subject to the overall requirements of the law of extradition, conduct constituting any of the following offenses, according to the law of the contracting state, shall be regarded as terroristic, and for the purpose of extradition shall not be regarded as a political offense or as an offense connected with a political offense or as an offense inspired by political motives. A. An offense within the scope of the Convention for the Suppression of Unlawful Seizure of Aircraft, signed at The Hague on December 16, 1970. B. An offense within the scope of the Convention for the Suppression of Unlawful Acts Against the Safety of Civil Aviation, signed at Montreal on September 23, 1971. C. An offense within the scope of the Convention on the Prevention and Punishment of Crimes Against Internationally Protected Persons, including diplomatic agents, signed at New York on December 14, 1973. D. An offense within the scope of any convention to which the SAARC member states concerned are parties and which obliges the parties to prosecute or grant extradition. E. Murder, manslaughter, assault causing bodily harm, kidnapping, hostage-taking and offenses relating to firearms, weapons, explosives and dangerous substances when used as a means to perpetrate indiscriminate violence involving death or serious bodily injury to persons or serious damage to property. F. An attempt or conspiracy to commit an offense described in subparagraphs A, 2, E, aiding, abetting or counseling the commission of such an offense or participating as an accomplice in the offenses so described. Article 2. For the purpose of extradition between the SAARC member states, any two or more contracting states may, by agreement, decide to include any other serious offense involving violence, which shall not be regarded as a political offense or an offense connected with a political offense or an offense inspired by political motives. Article 3, 1. The provisions of all extradition treaties and arrangements applicable between contracting states are hereby amended as between contracting states to the extent that they are incompatible with this convention. 2. For the purpose of this convention and to the extent that any offense referred to in Article I or agreed to in terms of Article II is not listed as an extraditable offense in any extradition treaty existing between contracting states, it shall be deemed to be included as such therein. 3. Contracting states undertake to include these offenses as extraditable offenses in any future extradition treaty to be concluded between them. 4. If a contracting state which makes extradition conditional on the existence of a treaty receives a request for extradition from another contracting state with which it has no extradition treaty, the requested state may, at its option, consider this convention as the basis for extradition in respect of the offenses set forth in Article I or agreed to in terms of Article II. Extradition shall be subject to the law of the requested state. 5. Contracting states which do not make extradition conditional on the existence of a treaty, shall recognize the offenses set forth in Article I or agreed to in terms of Article II as extraditable offenses between themselves, subject to the law of the requested state. Article 4. A contracting state in whose territory a person suspected of having committed an offense referred to in Article I or agreed to in terms of Article II is found and which has received a request for extradition from another contracting state, shall, if it does not extradite that person, submit the case without exception and without delay, to its competent authorities, so that prosecution may be considered. These authorities shall take their decisions in the same manner as in the case of any offense of a serious nature under the law of that state. Article 5. For the purpose of Article 4, each contracting state may take such measures as it deems appropriate, consistent with its national laws, subject to reciprocity, to exercise its jurisdiction in the case of an offense under Article I or agreed to in terms of Article II. Article 6. A contracting state in whose territory an alleged offender is found, shall, upon receiving a request for extradition from another contracting state, take appropriate measures, subject to its national laws, so as to ensure his presence for purposes of extradition or prosecution. Such measures shall immediately be notified to the requesting state. Article 7. Contracting states shall not be obliged to extradite, if it appears to the requested state that by reason of the trivial nature of the case or by reason of the request for the surrender or return of a fugitive offender not being made in good faith or in the interests of justice or for any other reason it is unjust or inexpedient to surrender or return the fugitive offender. Article 8. 1. Contracting states shall, subject to their national laws, afford one another the greatest measure of mutual assistance in connection with proceedings brought in respect of the offences referred to in Article I or agreed to in terms of Article II, including the supply of all evidence at their disposal necessary for the proceedings. 2. Contracting states shall cooperate among themselves, to the extent permitted by their national laws, through consultations between appropriate agencies, exchange of information, intelligence and expertise and such other cooperative measures as may be appropriate, with a view to preventing terroristic activities through precautionary measures. Article 9. 1. The Convention shall be open for signature by the member states of SAARC at the SAARC Secretariat in Kathmandu. 2. It shall be subject to ratification. Instruments of ratification shall be deposited with the Secretary-General of SAARC. Article 10. The Convention shall enter into force on the 15th day following the date of the deposit of the 7th Instrument of Ratification with the Secretary-General of SAARC. Article 11. The Secretary-General of SAARC shall be the depository of this Convention and shall notify member states of signatures to this Convention and all deposits of instruments of ratification. The Secretary-General shall transmit certified copies of such instruments to each member state. The Secretary-General shall also inform member states of the date on which this Convention will have entered into force in accordance with Article 10. In witness whereof the undersigned, being duly authorized thereto by their respective governments, have signed this Convention. done at Kathmandu on this 4th day of November 1987, in 8 originals, in the English language, all texts being equally authentic.